Hi, everyone.
Hello, everyone.
Hello.
All right. So this is the third part of our webinar series, and today we're going to be focused post I-526 approval. And last time we talked about concurrent filing in AOS. So this time going deeper on consular processing and the I-829 stage. So we will get started shortly. We'll just allow a couple more minutes for everybody to join in. I see a lot of our participants logging in now. So give us about 2 more minutes and we will get started. Okay. So, as I mentioned, we're focused post I-526 approval. We'll really dive into consular processing, what's happening out there in the field, and also then move on to the I-829 stage and get into some practical advice. I'm going to hand it over for introductions, but with the wealth of experience here from our panelist, Irina, both as formerly an immigration attorney and now on the broker-dealer side, and also Marjan's experience, a lot of very interesting insights. I really enjoyed preparing for this webinar and hearing what they're saying on the front line. So with that, quick introductions for those who don't know. Irina, you'd like to start?
Absolutely. Thank you so much, Kyle. Hi, everyone. My name is Irina Rostova. I am both an attorney and a FINRA registered representative. So I practiced for 10 years as an immigration attorney, very much focused on the EB-5 investor visas, represented about 700 families during my time as an immigration attorney. And a few years ago, I switched to being a licensed investment broker in order to help investors look at different EB-5 project options and make a qualifying decision that is suitable for them.
Thank you. Marcia?
Hi everyone. Thank you for being here and joining us this morning, depending on where you are in the world, of course. But my name is Marjan Kasra. I'm an immigration lawyer. I founded LawMax, Law Offices of Marjan Kasra, back in 2005. We are headquartered in Stamford, Connecticut. We also have offices in New York. We also have an office in Dubai and Istanbul. And I specialize in EB-5, and I actually specialize with dealing with more difficult sources of funds and paths of funds with countries in the MENA region specifically. And so we're happy to be here today, and hopefully we'll provide you with additional insights. Thank you.
Great. So real quickly, Marjan, if you can, just recap for us. The I-526 approval, once the investor has secured this, what is it confirming? And then how are we kind of moving to the next step in the process?
Sure. So an I-526 approval is one of the biggest milestones, I would say, in your EB-5 green card journey. What it signals to us is that the U.S. CIS has already considered your U.S. regional center to be compliant with all of their regulations. So it basically reviews the business plan, makes sure that this particular regional center does signal to you that they have the ability to create the 10 required jobs, or that they have already created these jobs. So for one thing, it signals that the regional center is compliant. For another, which is more important for you as an EB-5 investor, is that they have approved your main source of funds and the path that it took to get to the project. So basically, they've also taken a look at how you acquired your wealth, how you acquired your investment, and that they believe it was acquired legally, and that you utilize legal methods to get it to the project. So it's a great milestone, as I stated, and so once that approval is secured, basically USCIS is saying that you are able to obtain your conditional green card. And that condition is something that we will touch upon later. The only condition remaining is to make sure that your project can prove at the I-829 stage that they did actually fulfill their requirement for creating those 10 jobs. But essentially, you are qualified at that point to obtain your conditional green card, right? So once this happens, we go on and look at the visa availability. If you are from one of those countries that have retrogression, namely China and India, then it really depends on whether you filed pre-RIA, post-RIA. Are you with a regional center that's in a rural rural geographical area, or are you in the targeted employment area? Assuming that the visa bulletin is current, then we can provide you with additional guidance on what the next steps are. Essentially, USCIS will transfer your file to National Visa Center. National Visa Center is another agency that's within United States. And the National Visa Center will begin collecting additional documents from you, including Form DS-260, which is an application process very similar to a DS-160 if you've ever done one of those in the past for a tourist visa or student visa or what have you. But it's a little bit more extensive than the DS-160. And so in addition to the DS-260, we also provide to the National Visa Center the entire packet that we sent USCIS originally regarding your source of funds in particular, because we want to make sure those documents make it to the embassy. Once those documentations are complete, then they signal to us that you are documentarily complete, and they put you in what they call a queue or in line to be scheduled at the US Embassy where you are supposed to attend for an interview. So that's the long and short of it. And then prior to your interview, we always try to prepare you for the interview. I always believe in over-preparing my clients because we want to make sure that if you get a consular processing officer that is somewhat overzealous, that you would be prepared. And oftentimes they do question you about what the source of funds were. They want to make sure you know which project you're going to. So we make sure you kind of remember what you did 3-4 years ago, because by the time you make it in front of a US embassy consular officer, especially if you filed pre-RIA, there could be 2, 3, 4 years past from the time that you first invested your funds. So we try to make sure you understand exactly what transpired a few years back and that you would be prepared for any questions that may come up. And after your interview, assuming everything goes well, then your passports will be stamped with what we call an I-551 stamp, which is essentially an immigrant visa stamp. And it can be used as your green card until the actual green card is issued for at least 1 year from the date that you enter United States. So once you enter at the airport, that stamp is activated and it will be considered active as your green card for 1 whole year upon endorsement. So that's the brief version.
So a lot of information there. Let's maybe take it back. I think there are a few areas there where I'd like to focus in for the sake of the audience. This interview scheduling, I think we see it with our regional center clients a lot. Like, when is my interview going to be scheduled? There's a visa available. When am I going to be scheduled? Irina, Marjan, whoever wants to take it, what are some of the variables at play when we consider timelines for getting that interview scheduled?
Yeah.
Irina?
So Irina, why don't you?
Well, I mean, I'll start, and I think Marjan, you can add a lot of information as to the recent processing. So the variables are always consular availability, right? So different consulates may schedule interviews at different times. In certain consulates, they have availability a month from now. Certain ones you will have to wait 4 to 5 months. So the challenging thing about obtaining an immigrant visa, so unlike a non-immigrant visa, where you can often request an interview in different consulates and not necessarily in the country where you reside, when it comes to your immigrant visa interview, you can only request an interview in a country where you reside. So you're either a citizen or permanent resident of that country. So sometimes some clients are limited. So for example, if the wait time is in Poland, 6 months, that's what you're going to have to wait, unless you can qualify to move your case based on residency to another location. Another thing that sometimes took extra time that thankfully USCIS has more or less fixed. Once the case is approved at USCIS, it has to be transferred to the National Visa Center. And that transfer should only take a couple of weeks. But there were years when those transfers would take up to a year. Now, there were a lot of lawsuits filed, a lot of complaints, and it seems like USCIS has finally streamlined that process. So in the majority of cases, we do see a pretty quick transfer between USCIS and the National Visa Center. But if you are stuck at that step, it is also advisable to discuss your case with a litigation attorney to see if you can try to move it forward. And Marjan, I'll let you jump in there into what you're seeing lately.
Absolutely. So with countries that don't have a U.S. embassy, such as Iran, Russia, more of late, you are able to apply to any other country, to the U.S. embassy at any other country to which you have a valid visa to. So you don't necessarily need to be a resident of that country. So oftentimes our clients from Russia or Iran will travel. The Russians are getting appointments in Poland, or Iranians have designated embassies in Turkey, Armenia, and in Abu Dhabi. So those are the countries that you can go to, but essentially you can go to any other country so long as you have a valid visa to that country. But as Irina has pointed out, ideally they want to see you go to the country that where you are from or that you have a permanent residency. And so there are some exceptions where you could visit other embassies. That said, that process, I mean, if you look up, unfortunately, they don't publish actual data, so we wouldn't know exactly how long it takes to go to the U.S. Embassy in London for an immigrant visa. The State Department does publish non-immigrant visa data. Unfortunately, like with the immigrant visa, we just have to go by our own experiences, and at conferences, I always ask my colleagues, like, how are things at the U.S. Embassy in London, for instance, or how are things in China? So we kind of like go off of our own personal experiences. But just as a rule of thumb, 5 to 8 months seems to be fair game. Oftentimes we're able to secure them faster than that, but 5 to 8 months seems to be fair game. Now, if it goes beyond that, oftentimes, like, especially with Abu Dhabi and Ankara, Turkey, they are kind of notorious about being very slow, right? I believe they're doing a much better job in India and China, but some countries are just slower. And what we may suggest is to file for a writ of mandamus, which is where we file an actual lawsuit. Oftentimes in Washington, D.C., if there's no nexus between the investor and a given state, we always have to choose Washington, D.C. as the venue, and that writ of mandamus basically forces the State Department to proceed with scheduling of the interview. So we do have our way of trying to expedite these things. Prior to like recommending a mandamus, though, oftentimes if the investor has a family relative in the States, we may approach a state senator to see whether we could push the State Department to have the embassy actually schedule that interview appointment. If there's no nexus or connection between the investor and any given state, the only venue left is Washington, D.C. And that's like a whole separate webinar, I would say, because there are some issues with Washington, D.C. and filing of mandamuses. But if any of you are at that juncture where you are considering a mandamus, then please reach out to us, and we will be able to help you make that determination whether it's a good idea to file a mandamus. But essentially, the idea is to kind of follow with the agency. So if something is stuck with NVC, and as Irina pointed out, sometimes the transfer alone can take several weeks. And we always follow up with National Visa Center, we follow up with IPO, USCIS, and make sure that the transition happens quicker, sooner than later, if you will. And once that application is with NVC, we just have to, we keep very close contact with them and make sure that they have the documents required. And then if it is taking too long to schedule, then we, approach a senator, or worst case scenario, recommend the mandamus lawsuit.
So we have this NVC transfer piece. We have the embassy or consulate where it's being scheduled. Marjan, you said you've worked a lot with Iranian clients. Are you seeing country of birth play into it at all in kind of scheduling timelines that you're seeing?
Absolutely, because as I stated, you're supposed to go to the country that you're from. Provided there's an embassy. With countries like Iran where there's no embassy, then the designated embassy are Ankara, Abu Dhabi, and Armenia. So with those three countries, because they're so overwhelmed with their own population, they kind of put Iranian cases on the back burner. So unfortunately, yes, we do see a bit of a delayed, more of a delay with certain nationalities. And that's when we try to reach out to senators and file lawsuits as needed.
Yeah. And Irina, I know you work a lot with Russians who are also kind of without a country of birth embassy on the ground there. What are you seeing in those instances, kind of post-war?
Well, we were designated Poland as kind of like the designated consulate for Russian nationals. Many Russian nationals have been able to obtain residency in other countries, and they're going to those interviews. Overall, things are moving along quite well. Specifically, Poland actually, because they had so many EB-5 cases transferred to them, and it happened during COVID, well, post-COVID. They had so many cases transferred from Russia to Poland, they were not used to it. So they actually brought in who they considered to be an expert, and they were doing additional reviews and re-adjudicating all the source of funds documents. So I was not very happy about that. I've written to them and we argued that this is not, it's not consistent with the 2013 EB-5 memo by USCIS. So it caused, in my opinion, some delays, but I'm happy to say that for the vast majority of cases, overall, Poland is one of the best consulates that I've worked with. So they're very efficient. And so for the vast majority of cases, they were able to move them along quite efficiently. I would say around the world, if you have your I-526 approved, allow it 6 to 12 months. The vast majority of applicants will get their interview scheduled within 6 to 12 months after the approval. And if you are from a country that has, specific delays, just be in very good contact with your immigration attorney, because half the battle is just being proactive, emailing the documents quickly, communicating with NVC and so on.
So let's talk about preparing for the interview real quick. You touched on some interesting points there that I want to dive into, but I think if you're an investor and you're preparing for the interview, you have to understand the context of who's sitting across the table from you in this interview. So can you provide a little bit of color, what kind of level of discretion do these consular officers have? Is there just this easy checklist that they're running through? What's the variability in questions? And let's maybe talk about some horror stories, if I can say that, and some that have gone well, and how you would advise clients to prepare and go into that, both in frame of mind and in documentation.
We're going to have a Halloween-themed webinar.
Hey, it's October. We got to go there.
There's going to be a fourth session, Halloween session.
I'll get us started and then I'll hand it over to Marjan. Overall, I like to say, the vast majority of cases in EB-5, and in my 10 years of practicing, I mentioned I had about 700 investor families that have gone through me and my staff through the process. The vast majority, like 97%, it's smooth sailing. It's not always the fastest. Sometimes we have to wait for appointments, but it's smooth sailing. Back in the day, most of the EB-5 interviews were very simple. So it was like almost a formality. The consular officers were not re-adjudicating the source of funds. They would ask kind of 5 basic questions. When did you invest? What project did you invest to? How many jobs were created? You know, a little bit about how you picked this project, and maybe a couple of questions about the source of funds, just to kind of verify that the investor was who they said they were. Most consular officers were either not very familiar with the EB-5 program, or they understood that it's a complex program that USCIS had a whole department on, that those officers were experts. If they made a determination that this investor qualifies, then the consular officer's job was more kind of technical to make sure that the investors who they say they are, and that they in fact do have immigrant intent. With over the years, I would say over the last 5 years, we've seen EB-5 interviews go from a mere formality to very different levels of difficulty, and it vastly depends on the consulate where you're going. Some consulates, they have an employee who is looking at an EB-5 petition for the first time. They're not sure what to ask, and usually those interviews actually go pretty smoothly. And then there's other countries where the officers believe themselves to be EB-5 experts, and they also believe it is fully in their discretion to review and re-adjudicate the entire petition. And with those consulars, so we've seen, you know, more stringent interviews in India and in China, where they see a volume. In those cases, sometimes you will see a consular officer go deep into the source of funds and start asking questions. Now, what can possibly happen if the consular officer is not happy with the responses? Now, they don't necessarily have the power to deny your petition. Your I-526 was already approved, but they do have the power to send it back to USCIS for re-adjudication, which is very frustrating. I've only seen it happen a couple times in my entire career, and it usually happened when the consular officer was not very experienced. They asked some questions related to the source of funds and maybe additional source of funds, got scared, because when investors are talking about millions of dollars in this account and this property, a lot of consular officers are kind of, you know, sometimes their experience is not that much. And to them, they're like, oh, how are these people procuring these funds? And they flag the case, and they can send it to USCIS back for review and kind of fraud review. In the cases that I've personally had, those cases go through the fraud review, they come clean, and they go back to the interview, but it does cause a delay of about a year or two. So we absolutely want to try to avoid that by being prepared, knowing your source of funds, and giving very clear responses. You know, so it's just, I say at this point, all investors should know their source of funds. They should get the updates on the projects as of the date that they're going to the interview. And they should also be able to respond to questions about their own additional income and so on, so that they just don't raise any red flags. Because if a consular officer feels like there's red flags and they're unclear about how this person is earning their money, they may flag the case, which can cause additional delays.
Yeah, absolutely. And just to add to that, I mean, I often go to these American Immigration Lawyers Association conferences overseas, and it seems that with the overseas conferences, you know, they do oftentimes invite ex-consular officers, and they seem to be kind of relaxed about sharing their personal experiences with us. And my understanding is that no disrespect to any consular officers out there, but oftentimes, this is something that we hear from these ex-officers, is that they're not necessarily well trained when they start reviewing these things. So their training could be as short as 3 weeks before they start adjudicating cases at embassies. So oftentimes, they just don't have the experience, as Irina has pointed out. They have no clue about what the currency exchange rates are. They don't understand why this property that was bought 10 years ago is now 10 times what it was back then, because they just don't have a clue about inflation in certain countries. So oftentimes it comes down to the experience or lack of experience of a consular officer, and this is why we want to make sure that our clients are pretty much over prepared when they go in. Thankfully, I haven't had any cases go back to USCIS, but to answer Carl's question, they do have full discretion. So there's this concept of consular non-reviewability on top of everything else. So as Irina has pointed out, they could potentially flag your case and send it back to USCIS for re-adjudication. And oftentimes USCIS will consider that to be a valid concern. And it will cause several months, if not years, of delay, because I'm assuming, Irina, that you would then have to file a motion to reopen if in fact, USCIS chooses to revoke that I-5 they already approved I-526. They could theoretically revoke it. Then it's up to you and your lawyer to file a motion to reopen. It just makes everything messy and very it'll delay your case by several months, if not years, I would say. But so it's important to have you prepare, like over prepare oftentimes. And what we do at my law firm, and I'm sure Irina used to do that as well, is we would do a mock interview. We would make sure you actually understand your source of funds exactly as it was documented with USCIS initially, because what these officers do, and that's what their job is, regardless of whether they're experienced or not, they're going to be looking for discrepancies, and they want to make sure that there's like no discrepancy whatsoever between what was reported to USCIS and what you're reporting to them on that day. And if you're not clear on a detail, that could cause concern and they could flag your case.
Right. Very helpful. I mean, look, as a regional center owner, we've never seen any investors denied at this step. So to kind of reinforce it, I think also we don't spend a lot of time talking about it because we are really regional center focused in a lot of these webinars, but this is one of the things that working with an experienced regional center really helps you with, over going with the direct program where a regional center that maybe has only been around a year, right? We're sending full packages to these immigration attorneys so they can help their clients prepare. Project update reports that we've been providing to the investors, maybe interim economic studies that have happened along the way, really a full package so that an investor feels comfortable and can go into that interview very conversant on the, project details, even if they've never maybe been to the US and seen the project firsthand.
Absolutely. And Carl, just to add to that point, it's critical to go with a regional center that's experienced, that is very up and up on keeping with compliant with USCIS regulations, like Kyle's regional center, essentially because at the embassy, if there is any kind of a doubt as to the validity of the regional center, that could actually be one of the reasons that they could deny your case at the embassy. So sometimes if the regional center has lost its license for whatever reason, that could be a reason why they would deny your case at the US Embassy. So it's very important when you're choosing a project to go with a project that is very conscientious of keeping compliant with USCIS regulations.
Great. So moving through the process, we got through the 526 approval. We're out of the country, so we're dealing with consular interview. You've gone through the interview. You get the paperwork and the stamp. Real quickly, Marjan, I know you touched on this, but they have to enter the United States. How long from that interview and the approval there to entering the US? Is there any time limitation there that they have to enter the US within?
It sounds arbitrary, but the length of time you have from the time that they stamp your passport to when you actually travel has to do with the validity of your medical examination. So when you do your medical exams for an immigrant visa, they're generally valid for 6 months only. So if your interview happens and then they stamp your visa soon thereafter, you have approximately 5 months or so to travel. If it takes them longer to stamp your visa, sometimes you may have less than 5 months. So it has to be within that 6 months of validity. Sometimes if they're taking a bit longer, so for instance, some people are placed in what we call administrative processing post the interview process. So it may take a few weeks, so sometimes a few months longer for them to actually stamp your passport. And should that happen, oftentimes clients will have to redo their medical examination because, otherwise they don't want to be pressured to travel within like 2 weeks. So it depends on the validity of your medical examination.
Great, great. Okay, now we've got folks on a conditional permanent resident status in the United States. We go approximately 2 years and we're at the I-829 stage, or 90 days before that. Irina, can you talk a little bit about what's the purpose of this I-829 and get into some of the documentation requirement?
Yeah, so the I-829 is arguably the most important part of the process. That's actually removing conditions on the green card and making your lawful permanent resident status permanent for life. So the good news is, since I know it's a Halloween horror story webinar, but we just got the latest data from USCIS. The average approval rate for the I-829 petitions are 95%. So that's great news. That means the vast majority of projects are compliant. They're creating the necessary amount of jobs, and USCIS is able to confirm that. But the I-829 petition is the filing that the investor has to make 2 years after they obtain their initial green card. That filing has to show that the project was actually completed in accordance with the business plan and that the jobs were created. Now, the reason why it's extremely important to work with a good regional center is because 99% of those documents are prepared by the regional center. So the investor himself is not going to be collecting individual papers from the developer, the spending reports and so on. It's prepared as one package by the regional center and is shared with their investors. So it's very important to make sure that you're working with an experienced regional center. I don't know if you guys can hear my dogs in the background, but my dogs are oh, great, because they're barking. So it's important that you work with an experienced regional center. Some of the more unfortunate situations that I have ever seen in my career was when the client picked a project that they liked. They didn't ask much about the experience or the structure of the regional center. They got their initial green card, and then when it was time to remove conditions, no one was responsible for the I-829 package. So it was a lot of stress, months of working with immigration attorneys, reaching out to different parties to try to pull together the necessary documents and reports. And unfortunately, sometimes not everything is going to be available. If the developer is finished and they already exited the project, sometimes it's very hard to get the developer to send you financial reports. So it's a package that comes from the regional center. As long as you're with a reputable regional center, it should be a very easy filing for your immigration attorney. And then Marjan, tell me, I guess, what you're seeing right now. We're also seeing finally faster approval rates on that because it took USCIS. It used to take them a few years to adjudicate these. Post RIA, we're starting to see them adjudicating these in a few months.
Absolutely. So prior to RIA, they were taking upwards of 3 to 3.5 years. I would say that was considered normal. If you look at the average processing time, that hasn't really changed that much, at least on the website. But what we're seeing is actually approvals in 1.5 to 2 years after the filing. So they're doing, actually, to their credit, I don't say this often, but to their credit, IPO is actually moving faster with both I-526 and I-829 filings. So yeah, we're seeing them, and I would say 2 years is really a decent amount of time as compared to pre-RA timelines. That said, we also often talk to attorneys who specialize in federal litigation, and often I've heard of some lawyers who'd actually try to file a mandamus, maybe like a year, or I wouldn't honestly try it after 6 months, but I've heard of success stories after a year of waiting. So if you have exigent circumstances where like you feel that you cannot wait longer than a certain period of time, you may want to consult with an attorney to file a mandamus at that juncture. I mean, it depends on who you speak with, but some lawyers are more comfortable if at least 2 years have lapsed, if there's no specific circumstances warranting a lawsuit. But I would say 2 years is a decent amount of time within which you should expect an adjudication on the I-829.
Yeah. So going back real quick, this 829 really focusing on job creation and then sustainment of investment. And I just, for a moment, we always talk about job creation, and most people think about a head count of people working somewhere. When you're working with a regional center, most of us are using input-output models that are taking in expenditures and revenues and spitting out jobs. And so because of that, the package that we're helping prepare is really a financial package of dollars going into the project, being used for those job creating expenditures, and then an economic study that, based off of that financial flow of dollars, is then validating the job creation. It's been, I mean, for our regional center, our projects have 100% track record of qualifying our investors for their permanent green cards. And look, I can say the same for our competitors. For the most part, if you have a reputable regional center and the project is built, the job creation is occurring, right? It's very limited circumstances where I haven't seen that be the case. Now, going over to the other side of this, the sustainment of investment. I mean, this has been a big conversation lately. October of 2023, following the passage of the new law, the Immigration Service has come out and made some statement on this. Marjan, Irina, either of you, do you want to provide some commentary to that October 2023 guidance and how the service is looking at sustainment now, and maybe their kind of bifurcated approach to looking at sustainment?
Sure.
Marjan,
So,
do you want to have a go at this?
yes. Basically, guys, I let Irina jump in anytime too, but pre-RIA, you had to sustain the investment at least for the 2-year residency, conditional residency period. And oftentimes, because it took such a long time for you to actually immigrate to the United States, you ended up having your funds invested with your regional center a lot longer than, like 4 or 5 years. Sometimes the regional center would have had to redeploy your funds just to make sure that you fulfill the requirement of having sustained your funds within that regional center 2 years post your actual entry into the United States during your conditional residency period. What RIA did is they're saying that, look, they did away with that 2-year residency requirement. And instead, they're saying that once the money is deployed into the project, and it was a little bit of a gray area, and I think it may still be somewhat of a gray area as to when that period starts. But my understanding is that once all of your money is funded into the new commercial enterprise, then that 2-year marker begins. And legally speaking, you should be able to get your money back 2 years past that. That said, regional centers have their own maturity dates. So when you're considering any regional center, you should read your subscription documents, discuss it with the regional center, discuss it with your immigration lawyer, and have a good understanding of what is the prescribed in your subscription document, because then your money will have to be remain invested with that particular regional center for whatever that subscription document states. As far as immigration law is concerned, 2 years post investment into the NCE is sufficient, but that all goes back to which regional center you're working with. So with that, Irina, if you want to comment any further.
I mean, I just I very clearly remember we were having a conference in end of March 2022. The program just got renewed. And at the time, I was the chair of Public Policy Committee for IAUSA. And I remember Attorney Robert Devine saw me and he was like, we need to talk. I'm like, what's going on? He's like, did you see the text on the 2-year sustainment period in the draft? Because the legislature just passed. So the draft just came out and I'm like, no. And so he brought my attention to the fact that it just said the sustainment period is 2 years, not 2 years from the start of the conditional residency, not 2 years after the funds were deployed, just 2 years. And he was the one who was like, it seems like it was a drafting error, but sooner or later, USCIS is going to, like, they have to implement this and it's going to cause all this like havoc in the industry. And it's true, we actually tried to reach out to Congress people, tried to get them to respond with their intentions, what the text really was supposed to say. But being as it is, like we are at this 2-year sustainment period requirement. Frankly, I think I can confidently say that as a little bit of a drafting error. I don't think that was the intention of the groups that were, drafting the new legislation. But here we are, the law says 2 years. It doesn't specify 2 years from when. Is it 2 years from the wiring of the funds by the investor or the deployment of the funds into the project? So there's some gray area and there are some lawsuits right now taking place to try to get clarification. However, my advice to investors is, you want to go into projects that have the funds for over 2 years and can create the jobs. Another thing from a perspective on the investment side, and if we're talking about reducing your risk, so now speaking not as an attorney, but as a FINRA broker, just because the legal requirement is closer to 2 years does not mean that that's going to be a safe option for you for a project. So you want to have a project that doesn't take on additional financial risks to finish and repay the funds quickly. Because generally speaking, a project that can repay all the funds in just 2 years might be a little bit risky. The vast majority of construction projects require 3 to 4 years to fully complete. So keep in mind the legal requirements, but also keep in mind that you want your money also going into safer options. And if some longer terms are required to complete a cycle of the project, then that's what I would recommend investors consider.
So, as of today, the law was very vague to everybody's point here, but we have a website posting on the USCIS website. And as of today, it is 2 years from the money being made available to that job creating project, right? And so it's a brave new world. We've seen a lot of new terms. Irina, I think you make a very good point. On one side, we have immigration requirements and what qualifies an investor for that immigration benefit. But on the other side, you have to understand the investment documentation. Ultimately, this EB-5 investment partnership, the NCE, is making an investment into a JCE. And oftentimes that's an arm's length investment, right? These are separate parties. And so there are contracts that govern. And you really have to understand those contracts that govern because a project sponsor is not just going to say, oh, the immigration law changed, I'm going to change the terms of, how I took this capital and all of a sudden repay it early, right? It's pretty rare that would occur. And so, working with a good professional investment advisor really helps you understand the nuance of that because these documents are robust and they're a bit complicated. With that, I know we are coming to the end of our time a bit. We will hang around here for Q&A. We do have the chat open, so please feel free to use that chat. Any questions you like, we'd love to field them as panelists. Also, at the end of this, here I will provide you guys all email account information for all the panelists. We welcome you reaching out and are happy to answer any questions you might have. But with that, as we let some questions roll in, any practical advice around all this? I know we've touched on mandamus filings already a little bit. We've touched on these processing times and backlogs, but maybe can we speak to a little bit post-RIA? Are any of these new requirements on regional centers, on projects, on third-party administrators, are these things making your life easier as an immigration attorney, as an investment professional, in working with your clients?
From my perspective, absolutely. I think RIA is the best thing that's happened to the EB-5 program in a long time. For one thing, I can honestly give a little bit more confidence to my clients because there's third-party oversight requirements now with regional centers, making these projects safer than ever to invest in. I've always advised my clients to go with very strong, reputable projects. Look at their history, look at how many I-829s they have approval rate. You want to go with a project that has 100% I-829 approval rate. The I-526 is a little bit more investor dependent, but the I-829 I think is a good measure of a regional center. So in my mind, this is the best time to invest, especially with the set-aside visas now for Chinese and Indian nationals, allowing you to take advantage of visa availabilities in rural infrastructure and targeted employment areas that are high in unemployment areas. That said, I know this session was dedicated to more consular processing, but for those of you who are inside the United States, you now have the ability to file concurrently for your green cards. So that is also a big bonus in my mind for individuals who've been here on a long-term visa, like students or people who are here on H-1B visas.
Yeah, I agree. I think the RIA has been great. It has simplified a lot of procedures. I mean, we've seen just the change in how the filings are done now that we have the 956F filing going out from the project first with all the project documents, so that the immigration attorneys just have to file kind of the investor's individual documents without repeating all the project documents like we've had to do in the past. So that's been a massive, I think, change and improvement. On my end as a FINRA rep, I feel so much better with all the regulations and the requirements, because I feel like it's helping to filter out companies that were not interested in having best practices. Some of these companies, they already had really stringent, good practices implemented because they wanted to have good reports. They wanted to track all the funds and do the best possible job in managing these funds for their investors. And then there were other companies that kind of viewed, the potential of getting EB-5 investors as easier money or less expensive money, and they didn't hold themselves to the same standards. Now that they have to comply and they have to have a third-party fund administrator, I am seeing less projects coming to the market from those companies. So I think it's helping to filter out those who are not very serious, and helping to bring in people who are more ethical. I mean, just overall, and of course the processing times. I mean, finally, kudos to the IPO. The processing times have improved. They finally started to designate resources to the EB-5 program, and we're seeing average processing times now for I-526s between 8 and 12 months, which is fantastic and how it frankly should be. So overall, very pleased with where the program is at now.
And I know a lot of times when we talk about kind of present and forward for what the RIA has done. But Irina, I know we were talking about the backlog and the recent data there. I mean, can you speak to how much progress the USCIS has made on this queue of petitions that seemed for so long to be insurmountable?
So finally, we can say, because for the interesting thing that happened is the RIA was passed, and new investors who were coming in after 2022, they were getting adjudicated relatively quickly within a year. But we still had investors who filed in 2019 who were still waiting for adjudication of their petitions in the beginning of 2023. So 4-year wait times. Finally, I'm happy to report that USCIS has cleared the backlog. They, as of the latest reports from USCIS, they only had 100 I-526 petitions from pre-RIA that have not yet been adjudicated, and some petitions that where the visa numbers are not available. So there are still some applicants from pre-RIA, pre-2022 that have been waiting for a few years. Those petitions have not been adjudicated, but because they don't have visa availability, it's kind of to their advantage, because the longer their petition is pending, the more years they can deduct from their child's age. So it may allow them to preserve their minor children as minors and keep them part of the petition. But for those who have visa availability, only 100 unadjudicated I-526s, I think it's phenomenal. So I'm very pleased, and I've seen it, of course, for all of my past clients. They all got their adjudication, and now we're hoping that they can use the resources in those adjudicators and move them to processing new petitions. So that's going to help clear some of the backlog we have on the new ones.
Well, I'll say this is the first time in our 3 webinars that I think we were so comprehensive. You two were so comprehensive in your discussion and answering everything that we have no questions. So with that, I'll give you both an opportunity for just some closing words. Thank you to all the attendees. Really appreciate you taking the time and hope you found it as informative as I did. Irina?
Oh, thank you so much. Well, thank you for making the time, being present. You have all of our contacts. You know, the process is, it's not a simple process. So if you're embarking on this road, you will have questions. Feel free to reach out to any one of us, and we will guide you to the resources that you need to make your EB-5 process successful.
Absolutely, I agree. And guys, as I said before, I believe this is the best time to file for an EB-5, and the program is already kind of set out in motion, and it's we have a very specific program at the moment until 2027 at least. So I'm very pleased to say that this is the best time, and I would say, like, if you have to look at the history from 1990s to now, I think today is really the safest environment. There's always a risk involved, of course, but I believe your risks are minimized at this time, especially if you choose your project wisely. And for that, you can go to professionals like Irina, who is a FINRA registered broker agent. I will be happy to talk to you guys if you want to discuss your source of funds. Mention this seminar, and we're happy to extend an interview, an appointment to you to evaluate your case and see whether we could help you as well.
I think that's the perfect closing point, Marjan. I mean, this really is a golden era for EB-5. In our 15 years, we are seeing both the petitions process faster than ever, and also, I think, with the increased oversight and regulatory framework on regional centers and projects, we've seen kind of a rising tide to project quality in the administration of. So thank you again. Thank you to EB-5 Investor Magazine for hosting us, and we look forward to talking soon.
Thank you.
Thank you, Kyle. Thank you, guys.
Bye.
Bye-bye.